B. The trustee must be a disinterested person. Here, the trustee has not disclosed his or his firm's connection with the Chinese government, the CCP, or state-controlled businesses. However, it is clear that the Chinese government, the CCP, and any of the entities they control, directly or indirectly, are parties in interest here because they have demonstrated an interest in persecuting the debtor, decimating his finances and ability to recognize and extorting him to return to China, in many instances in violation of the laws of the United States. Thus, the trustee must disclose his and Paul Hastings' connection with the Chinese government.
The trustee must be a disinterested person, as defined in Section 101(14), 7 Collier on Bankruptcy Procedural 1104.02, citing 11 U.S. Code 1104(b)(d), relevant here. The term disinterested person means a person that c. does not have an interest materially adverse to the interest of the estate or of any class of creditors or equity security holders by reason of any direct or indirect relationship to, connection with, or interest in the debtor or for any other reason. 11 U.S. Code 101(14). Moreover, a statement disclosing potential adverse interests must be in writing and filed with the application to approve a Chapter 11 trustee. Federal Rule of Bankruptcy Procedural 2007.1c. The application shall be accompanied by a verified statement of the person appointed setting forth the person's connections with the debtor, creditors, any other party in interest, their respective attorneys and accountants, the United States trustee, or any person employed in the office of the United States trustee. The Bankruptcy Code does not define what it means to have an interest materially adverse to the interest of the estate. See 11 U.S. Code 101(14), Bank Brussels Lambert v. Cohen in Re-Arrogant Corporation, 176 F. 3rd, 610, 623, 2nd Circuit, 1999. However, courts, including the 2nd Circuit, have defined the phrase hold or represent an interest adverse to the estate as 1. To possess or assert an economic interest that would tend to lessen the value of the bankruptcy estate or that would create either an actual or potential dispute in which the estate is a rival claimant, or 2. To possess a predisposition under circumstances that render such a bias against the estate. ID. Citations omitted. In order to determine whether a Chapter 11 trustee is disinterested, the court needs to examine the connections between a trustee's firm and estate.
Here, the trustee has failed to disclose the connections between Paul Hastings and the Chinese government and CCP. However, it is clear, even from the facts known now by the debtor as of the filing hereof, that the trustee is not a disinterested person, and therefore should not be permitted to serve as the Chapter 11 trustee in this case. The trustee and the UST, which should both be aware of the obvious adverse position of the Chinese government and CCP, improperly have decided to pick and choose what information about conflicts they want to disclose. However, as the court in R.E. Panet Funding Group, Inc., 226BR 331-335, Bankruptcy NDNY 1998, has stated,
the trustee appears to believe that the court and parties should simply rely on him as a fiduciary to make an independent determination that he remains disinterested. Yet, this is not an appropriate determination for the trustee to make. Such an exercise in IPSE Dixit is not permissible, that the trustee internalize this decision rather than presenting the relevant information to the court and other parties for an objective determination of disinterestedness suggests that the trustee is selective about information he provides to the court and fails to acknowledge the high fiduciary standard to which he must abide to the point of punctilio.
Citations and quotations marks omitted. See also in R.E. Granite Partners, LP 219-BR-2235, Bankruptcy SDNY 1998. The professional must disclose all facts that bear on its disinterestedness and cannot usurp the court's function by choosing IPSE Dixit, which connections impact disinterestedness and which do not. Further, mere boilerplate disclosure may cover an inadvertent failure to disclose an insignificant connection, but does not suffice for known connections with parties presenting a significant risk of adversity. In addition, the trustee only disclosed his firm's connection with PAG at the July 8 hearing, and even then did not seem to have any idea about the scope of the involvement. In fact, even in his after-the-fact disclosure of Paul Hastings' relationships with PAG entities, the trustee was similarly vague. Supplemental Despins Declaration, Section 2.